If the California handgun roster were to disappear today, what would you get? Let me know down in the comments below. Hello everyone, today I have a very interesting court case to talk to you about. This case is being brought to you by the California Rifle and Pistol Association and Michel and Associates. It's their hard work that is making this happen. Today we're talking about Boland V Bonta, a lawsuit in the state of California challenging the state's handgun roster, the Unsafe Handgun Act, I believe it is called. Now, if you live in the state of California and you wanted to get yourself one of these Gen 5 Glock 19s, you would have a very hard time because this gun is not on the safe handgun roster. Many people, myself included, are forced to either choose from a very small list. I believe there are 800 handguns on the state's handgun roster. Realistically, that number is significantly smaller because things like color can affect its status on the roster, so there are many duplicates. We are very limited as far as what handguns we can buy. This causes a burden on many people because you're forced to either work with the very limited options that you have, which have existed since 2013 and previous, due to the state's requirements for loaded chamber indicators, magazine disconnects, physical safeties, and microstamping. There's a whole lot of requirements that it takes to get onto the safe handgun roster in the state of California, and it's what causes people to be forced to either choose from the list that is very small, or spend a ton of money acquiring one of these unsafe handguns through a private party or from an intrafamilial transfer. Some people also go the route of acquiring single-shot pistols, which are exempt from the roster. However, then you have to deal with the fact that modification of those per the California Department of Justice to semi-automatic could be considered manufacturing an unsafe handgun, which is a crime in the state of California. So if you wanted to get a gun like this, you're expecting to pay a lot of money, like I had to. Now, the reason I'm talking about this court case today is, first of all, it got announced today, and second of all, I am actually a named plaintiff in this case. This case, Boland V Bonta, has a list of plaintiffs, one of them being me. So I am participating in a lawsuit against the California Department of Justice, the state of California, and its ban on unsafe handguns. Now, this court case is very similar to another court case brought forward by the Firearms Policy Coalition, Reno V Bonta. However, Boland V Bonta is the one that I am participating directly with. I think that it would be awesome if another court case finished this first. It really, to me, it doesn't matter who secures the dub, as long as the rights of the people are respected and a dub is served in regards to the rights of the people. Now, this court case challenges the ban, and it specifically mentions a few things that I thought were important to touch on. The fact that many people are forced to choose from options that are older or coming on 10 years or older. The fact that the current list, the unsafe handgun roster, does not have there is not one single model of handgun that is on the safe handgun roster that currently complies with the requirements of the safe handgun roster. That might sound a little confusing to you, but here's the deal. Any handgun that was added to the roster with the loaded chamber indicator and magazine disconnect, those are the two big features that hold a lot of them back, they were added to the roster prior to the existence of the requirement of microstamping. Microstamping is a technology that, for the most part, I could just generally say, does not exist in any practical sense. Microstamping is a technology that would be required to imprint on 2 points of the casing of a firearm, and now recently just 1 point, but it would have to imprint on the casing of a spent shell the identifying information of that firearm, which could then be used to trace who shot that round. Now, there's a lot of problems with that, but we'll get to that in a second. However, many handguns, including the Glock 19 Gen 3, one of the the quintessential handgun of America, I would go as far as to say that. The Generation 3 Glock 19 is currently on the handgun roster. That gun does not have a physical safety. It is drop safe. It does not have a loaded chamber indicator as defined by the state of California. Yes, you can use the extractor to determine whether or not it is loaded, and they do call that a loaded chamber indicator, but it doesn't meet the state's definition. It does not have a magazine disconnect, meaning that you would not be able to. A magazine disconnect is where if you remove the magazine, you could not pull the trigger without having a magazine inserted. Now, interestingly enough, somehow all of these guns on the roster do not meet the requirements of microstamping. So the state of California has determined that in order for a handgun to not be unsafe, it must have a loaded chamber indicator, magazine disconnect, and microstamping. However, on the state's list of approved handguns, none of them comply with that. So they are simultaneously saying that you cannot buy, unless you're a cop, they are saying that you cannot buy these firearms, and then somehow saying, but yeah, you could buy those firearms that don't meet this definition and are unsafe per our own definitions. That's totally fine. This lawsuit is also targeting the Interstate Commerce Clause. Now, in the state of California, if someone were to live in another state and move to this state but not have a California ID, they could not sell you those firearms. There are many ways that this affects who and what can be sold from state to state, person to person, whether they come into the state from out of state or not. There's a lot of difficulties that come into this because there is not currently very many ways for people to engage in lawful commerce in the state of California in regards to off-roster handguns. Now, this case specifically brings up the court cases of Heller and Bruin, which both determined that in order to look at a Second Amendment case, you have to use the text, history, and tradition rules in order to analyze whether or not a law is constitutional. Previously, I believe they were using the means end rules where they would say, hey, we're trying to ban this because we want the ban to do this. We want to reduce crime, so we're banning these guns. We think that banning these guns will reduce crime, therefore it's allowed. It's all good. And the Ninth Circuit typically would say, yeah, right on. Very rarely did the Ninth Circuit not rule every gun law in the state of California as constitutional. I'm going to close my window because the dogs are barking. The ATF must be investigating next door. Now, that's a joke. Relax. So, and now because they were previously using that, many court cases when they made it to the Ninth Circuit were able to be ruled constitutional, meaning that most of our gun rights were being infringed upon, and we were waiting on cases to make it to the Supreme Court. Some cases that made it to the Supreme Court have been kicked back down in light of Bruin, forcing them to use the text, history, and tradition route to determine the constitutionality. Now, you might be wondering, Reno, is there any sort of history or tradition regarding the banning of handguns based on specific feature sets? Well, not really. I would be as willing to say as I think the state will have a very hard time arguing, whether in good faith or not, who knows, that there is a history and tradition of banning handgun possession and purchase and limiting it to what type of handguns you can buy based off certain specific safety features, while also still allowing them to sell even older ones that didn't have those safety features. I'm going to go out on a leg and say they're going to have a very hard time arguing that this case does not stand on its merits well. Now, I think that this case is going to be very successful. I hope it's very successful. If you want to support, you can obviously support the California Rifle and Pistol Association. Them, along with the team at Michel and Associates, they are the ones doing the work. They are doing the legwork. A lot of people have been congratulating me. I am simply a plaintiff that is being represented. I am not doing the legwork. I am not filing these lawsuits. It is being filed on my behalf. They are representing me and others. The CRPA is doing great work here. I'm very happy to be a part of this. Hopefully this makes some headway, and hopefully we can do more stuff in the future. Let me know what you guys think down below. You guys know the drill. Have fun, be safe, stay dangerous, peace.